So, hi, I'm Caroline. I'm the digital marketing manager here at Bobtail. We are a financial services company, and we cater and develop solutions, financial solutions for carriers, and we have a specific focus on small carriers, owner-operators, and small fleet managers. If you want to learn more about that, go to bobtail.com. We'll talk about that later, but what we're really here to talk about is how you can learn your rights and responsibilities as a carrier. And again, like I said, we are going to record this and it's going to be up on our YouTube channel. So go to Bobtail Capital. You can find us there on YouTube and hit the subscribe button and go ahead and like our videos. We have all kinds of videos up there. Also, all kinds of blogs and articles on our blog about everything from how to avoid freight fraud to how to book your first load, how to book your millionth load, and how to start and run an effective trucking company. And we also have a Facebook group. So if you have questions about the industry, go over to Facebook, join our group, and just post in there whatever questions you have. And even if I don't know the answer off the top of my head, or Alejandra doesn't know the answer off the top of her head, we'll go out there and we'll find verified answers, because you can type those things into Google. But an algorithm is gonna give you the answer. You could type them into ChatGPT, but they don't always give you the most verified response. We have a lot of access to good information, and folks like our very esteemed guest that is joining us tonight. So I want to welcome David Jencks, who is a transportation and commercial finance law expert. David comes to us from Jencks Law PC. So if you're interested in that, we can drop a link to his website so you can learn more about him. But we are so excited to have you on the line, David. And I promised I wouldn't sing too many of your praises before you had a chance to introduce yourself. So I'll cut it out there and let you introduce yourself.
Well, there probably aren't too many praises to sing. My name's David Jencks. I'm an attorney. I've been an attorney for almost 25 years. For 24 of those 25, I have worked in the transportation finance and transportation arenas.
Excellent. And a member of the Transportation Lawyers Association. We're talking to someone tonight who has over 20 years of experience in this area. So we are really in fine company tonight. And I have some questions for David that I'm going to rattle off in the beginning to get us started. And then we are going to take audience questions. So the questions that you have about legal rights and responsibilities of trucking companies, we want to know what those questions are and if we can help find some answers. Now, I want to talk first about the carrier-broker relationship, David. So what are some of the most important legal aspects in this area? We know every time we book a load, we have a we have a broker agreement that we have to sign with every new broker that we work with. But I think sometimes people just kind of sign those, without looking too carefully at them. And I know that there are a lot of aspects to those agreements that could be very, very important and either protective or not to carriers. So can you talk about those agreements?
I can certainly talk about what I think are the most important issues within those agreements. But I think before I do that, I think it's important to recognize sort of the real world reality for many carriers, particularly smaller carriers. And that is that you might need a load. You might need a load home. You might need a load between a couple of different loads. And it's very, very difficult, and we should just all acknowledge it's very difficult in those situations to try to negotiate a broker carrier contract if it's not a regular client of yours or you're not going to regularly haul for that broker. But if you are entering into a relationship with a broker that you're going to do a lot of work with, I think it's extremely important to at least understand what you've signed, and possibly push back a little bit, or possibly try to negotiate that a little bit. So,
Yeah.
so with that background, I would say that by far the three most important aspects of a broker carrier agreement are: what does it say about claims? What does it say about offset or unilateral offset? And what does it say about a waiver of rights? The really tough broker carrier contracts out there, there's a sentence in that agreement that says that you waive any and all rights under federal or state law that aren't specifically contained within that broker carrier agreement. In other words, you lose all your statutory protections, you lose all your administrative protections, they're gone.
Wow.
So when that sort of language is in a broker carrier agreement, you are really stuck to the four corners of that agreement. It's very tough to go out and cite any law or rely on any law at that point. The second issue, and it's just a constant problem for carriers, I feel like I just feel like it's almost all I deal with right now. And that is the claims issue. As soon as there's a claim, of course that load is an issue. And of course that load's not going to be paid. But the 10 before that you haven't been paid yet also go on hold. And the broker immediately says, I don't have to pay those either. I get to try to offset that. I get to try to hold those funds to reimburse me for the supposed costs or supposed expenses that I've incurred. So what does the broker carrier agreement say about claims? Does it say we're going to follow the Carmack Amendment, which is a federal law that's a little bit more fair and even-handed to carriers and shippers alike? Or does it say that you waive all those rights and you lose all those rights? And then, of course, the third thing would be, what does it say about offset? Does your broker carrier agreement say that if you sneeze wrong, the broker has the right to never pay you for any load anytime ever? Because the reality is, some of them say that. No, not all of them. And I don't want to pick on every broker in the world, and I don't want to pick on every broker carrier agreement in the world. But the reality is, if we started naming some of the big brokers, their agreements allow for unilateral, meaning they get to decide, offset of any and all loads that you've hauled whatsoever if there's a problem or they think there's a problem. So those are the provisions that I would focus on. What does the broker carrier agreement you're being asked to sign say? And is there anything that you can do, or that we can do, to try to push back a little bit and say, hey, how about some other language? Or how about not that language?
Right. And I think you're right. I like that you started off with the reality. Here's what the reality of what a lot of carriers face. And now we're going into these three areas, because I do think with some of the bigger brokers, you don't really have a ton of leverage, right? But you may have leverage with smaller brokerages or brokerages that you have worked with a lot in the past and you have a good working relationship with them. You might have some leverage to say, hey, I am happy to continue to run loads for you, and I just need this language in the agreement.
Terrific point. Absolutely terrific points. And sometimes it might not even be, I need that language in the agreement. Maybe it's just, I need that language out.
Yeah.
I'll say something sort of for the purposes to spur some thinking and discussion. And it might sound extreme, but I'm serious. Most carriers would be better off running without a broker carrier agreement than they would having signed one.
Wow.
You have more rights under federal law. You have more rights under common law, usually, if you didn't sign a broker carrier agreement than when you do.
Interesting. Is that something that is can I extrapolate that into advice of don't sign the agreement or don't have an agreement?
Well, I'll be a little careful about rendering any specific legal advice tonight. But what I can say as general advice is, if you have the option, sign a broker carrier agreement or don't sign it. You'll actually, when you come to somebody like me, you'll have more rights when you didn't sign the agreement than when you did. So if the option's available to you, don't sign a broker carrier agreement. Let's let the bill of lading control.
Interesting. That just blew my mind. I don't know if that blew anybody else's mind, but it certainly did mine. And I wonder if people have experience even having that option to begin with. So I want to, and Avisolo, I promise we'll get to questions. I am going to respond here, though, to something David said before we get to questions. I want to kind of summarize those three aspects and make sure that I understood them. Because I have not gone to law school. I have not had the pleasure. And so I might not understand every legal term that you use. So claims is about if something goes wrong with a load, how might that affect me getting paid for previous loads that
Correct.
I've hauled, right?
Correct.
Waiver of rights is what does it say about waiving any rights that are in common law, that are already understood and on the books in common law and are not listed in the agreement?
Yeah. And typically what I would refer to it as a blanket waiver. There's language
Okay.
in the broker carrier contract that says you waive any and all rights that aren't specified in this agreement. They won't make it specific. They'll just
Right.
say any rights that aren't in this agreement.
Got it. And then offset, that was a term that I was not familiar with before. Can you just talk a little bit about how do you define offset and what that means again? Can you repeat that part of it?
Sure. And offset's terribly, terribly important. It's why so many carriers really run into roadblocks fighting a broker to get paid. So many broker carrier contracts have a paragraph that will be entitled offset.
Okay.
And the concept of offset is if the broker is holding some of your money, they haven't paid you yet. So they have $10,000 of loads that you've hauled, and they suddenly assert a claim for $50,000. They get to take that $10,000, keep it, and apply it to the amount they say that you owe. That's offset.
Got it.
They're going to take something that they're holding that should have been yours, that was coming to you, and now they get to say it's ours now, and we will apply it to any debt that's owed.
Got it. Understood.
Or
So
that we believe is owed, I should say.
Right.
It may not be actually owed, but the broker's asserting that it's owed.
Right. So it's the reason it's called offset is that they're offsetting their cost of one thing and covering it with something else that
They are
do.
trying to offset what they claim
they owe
are
you.
their costs or expenses. That's right. Or damages. Yes.
Right. So it occurs to me that some of these clauses in broker carrier agreements, the first thing that comes to my mind when you when you describe those is, how is that even legal? So how is it even legal that a carrier would be able to sign away every right that they have under common or under law that's not
Under
in
any
the-
law, whether it's statutory or common? It's a wonderful question, and it's hotly debated among transportation attorneys. When I sit at the Transportation Lawyers Association, I mean, we talk about those kinds of things. I actually believe that that's not legal. I think that if you're going to waive your rights, it has to be specific. What right am I waiving? Not any and all, not every, but a specific waiver. So I've actually argued in the courtroom that blanket waivers aren't legal. Now, there are decisions that support my position and there are decisions that cut against it. That's the reality of the common law. That's the reality of being in a courtroom. But blanket waivers that don't specify what rights exactly you're waiving, I contend, that's not enforceable.
Interesting. Is that something that if I were to say as a carrier to a broker looking at a carrier agreement or a broker agreement going, this isn't really enforceable in a courtroom, right? Is that something that typically is won by carriers, or does it just kind of depend on the situation?
I think the only way a carrier wins that is to actually take a slightly different tact. Usually it's just one sentence in the agreement. And the way to appeal to the broker is to say, I just want that one sentence removed. Rather than challenging them, rather than threatening them with a courtroom, hey, can we just remove this sentence? It's such a simple, easy request, at least on its face.
Right.
And there are brokers that sometimes can and will, but I always think we should stay grounded in reality. There's sometimes a divergence of the law
Totally.
and reality. And It's very difficult to get a broker sometimes to change their agreement. But again, like you said, if you're hauling a lot for that broker, if you have a good relationship with that broker, there's a chance that you can get some contract modifications.
Right. Right. So what are some other potentially common practices in the reality that we're talking about that do violate transportation law? Are there other pieces of a broker carrier agreement that you have seen that really don't hold up in a courtroom, but are there because they're just taking advantage of that ignorance?
That's a great question, but I probably would have to say I don't see a lot of provisions in a broker carrier contract that are illegal on their face. I think that there's questions about how to read the broker carrier contract and how, to what extent it's enforceable, some of the waivers, some of the supposed rights of the broker. But I can't say that it's typical to see a broker carrier contract with a lot of patently illegal provisions in it. It's possible, but it's not
Sure.
likely.
Got it. Got it. So what kind of information does a carrier have the right to request from a broker? We've seen broker transparency in headlines a lot in the last year or so, and it always kind of comes back in every couple of months. What's the deal with that? What does the law say, and what's actually done in practice?
Yeah, it's been a hot issue. I'm sure that many of the people that hear this talk will have heard about it, read about it. You really asked a two-part question. So maybe let me first answer right now, today, what does a carrier have the right to ask of a broker to produce? And the answer is virtually nothing. The broker needs to produce a bill of lading, possibly if for some reason you don't have it, or a rate confirmation if for some reason it's been lost or you don't have it. But there is very little a broker has to provide to a carrier. And that sort of leads into the second part of your question. And that really was, what's broker transparency? What is that? In 2020, there was a comprehensive overhaul of some transportation law. Since that time, OIDA, on behalf of small carriers, and the TIA, on Transportation Intermediaries Association, on behalf of brokers, have been fighting on Capitol Hill in Washington to determine to what extent brokers do need to provide information and be transparent with carriers. And the primary issue is, should a carrier be able to receive pricing documents between the broker and the shipper? So should the carrier be able to say, this is what the broker and shipper negotiated this load to move for? So then the carrier knows, what percentage of that am I getting? What am I getting out of that? That's what carriers have been pushing for. Can we see the pricing documents between shippers and brokers? The Transportation Intermediaries Association, TIA, stood up and said, oh, no. We don't want that, and we're going to fight against it. There is going to be at least a 4-year battle over that issue. The FMCSA has said that parties have until October 31st of 2024 to submit comments on this issue before they even take up the testimony to start making the rules and start making the laws to determine how much broker transparency there should be. So I'm guessing, based on the way Washington works or doesn't work, we will be having this conversation in a year to try to determine if there's been any broker transparency legislation. But it's not even until the end of this year. Everyone has until the end of this year to submit comments on the issue. So Washington's not going to take it up till early 25. I think that's the reality. Right now, there is no broker transparency. It's a great term. We all love it. I think we all hope for it, probably everyone on this call. But the reality is there's no broker transparency law right now. There's nothing to enforce.
Nothing to enforce it, right?
No.
It reminds me a little bit of the salary transparency, some of the conversation around salary transparency that you're seeing in state by state of when you post a job, you have to put some kind of range of the salary. I think California is doing that. And I think that's sort of in the same vein as broker transparency of how much is this load actually going for and what's the percentage that I'm actually working for.
That's the concept, but right now that is not law.
Right.
Yes.
Right. Okay, so I know we have some questions about claims. So in that vein, what, if any, recourse does a carrier have for a broker who refuses to pay a load or pays less than what they agreed to for the load?
It's probably the worst answer that I could give all night. But everyone deserves the truth. Everyone deserves the reality, and many of the people on this call probably already know the reality. There will be very few times in the broker-carrier relationship that the carrier has less power than when the broker asserts a claim. Whether the claim's legitimate or not is not the issue right now. We're talking about the fact that the claim's there's been a claim made. That's it. Legitimate or not. At that point, the carrier is in sort of desperate defensive mode because the 5 loads before that they hauled for the broker aren't going to be paid.
Right.
That load that's subject to a claim is for sure not going to be paid. And the broker is probably, but not for sure, starting to try to make insurance claims, gather insurance information. Maybe lawyers are already involved. So when you ask me, what does a carrier do? There are a couple of businesses, and I could provide this later. I can't do it right off the top of my head. There are a couple of businesses that work on claims dispute resolutions. There are collections firms that do that. Factors sometimes do it for their carriers, of course, because they all have a vested interest in that issue. But unfortunately, lawyers oftentimes get involved.
Right. So in the case that you have a carrier that's not, or a broker that's not paying a carrier for a load, when does the surety bond come in? So we know that brokers are supposed to have the surety bond. When are we able to make a claim on that, and how successful is that usually?
Yeah, and what you're really asking is, when are you going to make a valid claim on a surety bond? Because the reality is you can always make a claim. But what federal law says is that claims on bonds are only legitimate or should only be made, and the bond company only has to pay out if it is for the financial inability of the broker to pay. Brokers going bankrupt, brokers out of business, broker disappears. Now the surety bond claim is very valid. But oftentimes I see carriers, and I can't blame them, but oftentimes I see carriers frustrated with the claims process and they try to make a claim on the bond. Federal law does not require the surety to pay out on a claim because the broker is going to say, I can pay, I don't want to pay.
Right.
And there's a difference. So valid claims on surety bonds need to be in the case that we've got a broker that's out of business, going out of business, bankrupt, those sorts of things.
Right. And in what cases could we then go to the shipper if the broker is not paying for the load, but we have all of the evidence and all the evidence is in our favor? Is there a way that we can go to the shipper and ask them to pay the carrier directly?
Well, you can always ask. Here's some guidelines on pursuing third-party collections, particularly against shippers. If the broker just refuses to pay, then I strongly suggest shipper collections, attempts at shippers. If the broker's just a crook, unwilling to pay, disappeared, then we should absolutely be pursuing the shipper. We should absolutely be pursuing the shipper if the shipper didn't pay the broker. then we certainly should
For
be
sure.
pursuing. Yes, but I will first say, lose any belief that there is concrete black and white federal law out there saying that if the broker doesn't pay, the shipper has to. That is not true. That is just not true. There's no statute that says that. There's no regulation that says that. It's not true. Any law in that vein comes from case law, comes from common law. And what's incredibly frustrating for transportation attorneys like me is that there may be no more area of the law that's more conflicting from state to state and jurisdiction to jurisdiction than this issue. Some jurisdictions say carrier must be paid. Carrier's going to have to pay twice. There are other jurisdictions that say we almost never make the shippers pay twice. So oftentimes it depends on what jurisdiction are you in, what state, what federal circuit. So the law varies wildly, but I can give some rules of thumb. If the shipper hasn't paid the broker, let's go after the shipper. If the broker just won't pay because they're a crook and disappeared, let's go after the shipper. But in cases where the shipper has paid the broker and there's some dispute over the load or how the load was hauled, or there's some dispute over how much the carrier was to be paid, those are very, very difficult collections against shippers. And those don't oftentimes prevail.
Understood. I wanted to just remind everyone that we are going to get to questions. I actually just have 2 more questions here, but I think I'll just do one so we can get to more questions from the audience because I know we have a lot. And if you have questions that you don't want to forget, go ahead and put them in the chat and I'll call your name out to ask it after this last question. So the last one is an example that we got a call. Obviously, Bobtail, we're a factoring company. If you missed that at the beginning, we do financial services for carriers. One of those services is factoring. And so we had a customer that called us and they were confused because they had gotten a call from someone who really didn't do a very good job of identifying themselves in the beginning. They said, hey, you hauled this load for us, but it was more than 30 days ago, but we now see that there's some missing freight from that load, and we're going to charge you $200 from the next load that you deliver for us because we have missing freight from this other load. Come to find out when he's digging into this and looking up, and because this was more than a month ago, so he's trying to go back into his records and figure out what happened here, he realizes that the person that called him was not actually the broker, it was the shipper. And so what he called us then to ask, was this paid by the broker? He was asking some questions, and we advised him, hey, call the broker because your business is really with them. But it made me wonder, is that something enforceable that a shipper would be able to do? And if not, where's that shipper coming from? And in those kinds of cases, what have you seen?
In your factual scenario, what the shipper's trying to do can't be done. It's not legal. The issue is the carrier better know that on that broker-shipper relationship, if the carrier's going to haul more loads, it still may happen. Because what I can tell you is what's legal and what's not, and that's not legal. What you described isn't supported by any sort of law or really any broker-carrier language. But it still may be attempted because, again, what's legal and what actually happens in the real world can diverge. Right.
Absolutely. So that was the advice that we gave. And when we are advising carriers, we're always going to say, just go back to the broker, ask them. Your business really isn't with the shipper unless you're working directly with the shipper. And in that case, it would be. But in this case, it was a broker load. So you need to do the business with the person you do business with, not with anybody else.
Yes. Yep.
All right. Let's get to some questions here. I know this is the, we've got a first one from Abisola, that how to get into business without signing a contractual agreement. Abisola, do you want to go ahead and ask that question? If not, I can ask it for you if that's all right. So how do you get into business without signing a contractual agreement, considering the standard practice in the market? So I think this comes back to a broker carrier agreement. How could you get out of that if it's already a standard question or a standard practice in the market?
Yeah. The reality is that it would be very difficult. I don't want to make that sound like it's possible. Certainly, if you're not being asked to sign one, I don't believe you should sign one, and you shouldn't ask them about it. If they are pressing you or pushing you to, you can always ask, hey, can we just let the bills of lading control and handle things? But I'm fully admitting here tonight, I might be a lawyer, but I'm not out of touch with the real world. And I realize most of the time the broker is going to insist on their agreement being signed.
Absolutely.
Yeah.
All right.
Yeah. A rejoinder to that question.
Yeah.
If you permit me.
Yeah.
Aside those clauses that you said we should watch out for in the contract documents, like the waivers, the claims, and the setup or the offset, what other clauses can we also watch out for?
What other clauses?
Yeah. Aside those three things you mentioned.
I mean, many broker carrier contracts can run 10 single space pages now. I mean, it's not uncommon. I'm very focused on waivers, claims, and offsets. I mean, certainly you should probably be focused on, does the contract say how many days to pay? Is someone trying to take advantage of you or your factoring company and paying in 75 or 80 days as standard practice? That's not the industry average. So certainly you could agree to something like days to pay. There's also language sometimes in broker carrier agreements that say, hey, we don't have to pay you until the shipper pays us. So that's called pay when pay clauses. And I hate those too, because then we don't know what the relationship between the broker and the shipper is. So if the broker's saying, well, we haven't been paid yet, so we can't pay you. How do we know? We don't know. So I don't like seeing carriers sign agreements that say, hey, we get paid when the broker gets paid.
That makes sense. I know this is the wrong name, but I think Anna Chovanyan has the next question.
I totally agree that it's kind of not possible, even with those brokers that you are holding, for a long time basis. It's really difficult to negotiate the contract, because especially nowadays when brokers, they just can send you away and get another company to hold their load. I'm in car hauling industry, by the way, but we have one specific case about the claims. So I have been notified about a claim after a year. So the broker didn't notify me. Usually they do within 48 and 72 hours, right? Most of our loads we take to the ports. Port staff, they have to, it's subject to inspection. They have to check vehicles, etc., etc. And there is really nobody who can sign for the driver, right? They took the load and they didn't claim anything. And then after a year, they put on hold $70,000 for many claims that we never received. And the same company, another company put $33,000 on hold for 6 months, and then it turned out they are sending me damages for $19.38 for each vehicle, which is like maybe the port associate when taking out the tape of the vehicle, maybe noticed some kind of scratch. Then they put a $19.38 labor, $90.38 labor, not even a part or damage or something like that. So they hold my money for 6 months for $19.38 for several vehicles and kept $33,000. So, and the first question, when they hold it like 70,000 in order to, when they even didn't notify me about the damages, my drivers, they quit. They had already gone. I had nobody who I could get the money from. You know what I mean? That's the first question about the claims.
Well, Yeah, let me hit on a few things that I hear in that. I probably should say that nothing I say tonight should be completely relied on as legal advice. You should always hire an attorney. You should have an attorney meet with just you and talk those sorts of things over. And the other thing that I should say is that it's very difficult for me to give any concrete legal advice because I'm not reviewing the documentation. There's certain documentation that's involved, and of course, I'm not privy to that on this call. But here's what I can say generally, just to give you some guidance. Federal law says that any claims that are submitted have to be submitted within 9 months. So if you haven't waived that, a claim a year later is totally invalid. If you have waived the claims period in a broker carrier contract, if you have in fact waived it, you still have a heck of an argument to say that that's absolutely not reasonable. Because all contracts are dictated by the concept that there must be some reasonableness to them. And the fact that they're coming back a year later trying to assert multiple claims that could have and should have and probably would have been discovered months and months and months and months before, I think that's one you've really got to stand up to.
My second question was related about attorney help. Attorney associate help. I'll ask whenever you give me time for that.
All right, sounds good. We'll come back to you. We've got a question from Abdul Rahim Mufti. Do you want to ask your question on the mic, or
Sure, that's fine. How are y'all doing?
I'm doing well.
Good. So we were hauling for a company called Goodwin, and they went out of business. We do drayage loads. And they went out of business, and the loads we hauled for them, their MC was still active as a broker. They went out of business, and now I'm having to pay my factoring company back because it was bought on recourse. And I want to know, they're saying that we can't file against the bond because the MC is no longer active. Is that accurate?
That's not accurate. I hear that lousy excuse by surety companies and bond companies all the time to deny claims, and that is not a legal, valid reason to deny surety claims. Absolutely not. That I can be quite emphatic about that answer.
Okay, I appreciate it. Thank you so much.
Mm-hmm.
Yeah, and just something to keep in mind for about factoring companies. So I just want to add in there from the factoring company perspective. There are some factoring companies that, as part of the service, won't necessarily go after claims, right? Their service may end with giving you the upfront money that you need to cover your expenses, and that's what you're paying for, and that's kind of where it ends. And a lot of factoring companies will expect the carrier to follow up with the broker to make sure that the factor then gets paid, and any claims made on the bond or on the surety aren't always handled by the factor. So it's important when you're selecting a factoring company, and I highly recommend that every time your factoring agreement is about to expire, hopefully you know when you're supposed to give notice, that you go and look for another factoring company and just see what kind of rates you can get and see what kind of terms and conditions you can get around those things. Because if you're with a factoring company that's not helping you follow up on payments, that's not, in our view, that's not a complete service. You should have the kind of guidance and accompaniment with your factoring service, and they should be able to help you with this kind of information, and at the very least guide you with the correct information and be able to ask these kinds of questions for you and get the right answers. So that's just kind of a piece of advice for anyone who's looking for factoring. Ask about that. Don't just ask about the rate, the factoring rate. You can get a really low rate, but if your factoring contract or factoring service doesn't include everything that you need, then it doesn't really matter that you got a low rate, because you're going to be spending so much time trying to figure things out like this without any help, that it would be better to have a higher rate and get a better service. So that's
since you're talking about factoring, what is the difference in like a factoring company like funding you for it, and the 30-day recourse, 60-day recourse, or them just funding it? Like, what? I don't really understand that either.
Sure, sure. So I think it's a difference, and I can also explain the difference between recourse and non-recourse.
Okay.
So the difference between those two things, a recourse agreement generally means that if the broker doesn't pay the carrier, doesn't end up paying the carrier for the load, that the factor can then charge back that money to the carrier, right? So if you deliver a load for $1,000 and the factoring company gives you, $997. And at the end of the 30-day period or 60-day period when the broker's supposed to pay that, if they don't pay, then the broker can come back and charge back that money to the carrier, right? And then you have a negative balance in your account. Now, under what circumstances will the factoring company try their best to get that money for you? So they're gonna how good is their claims process? How willing are they to get some money from either the bond, the surety bond, or from the shipper? That's sort of up to the factoring company of how hard they're going to work for you, right? And so even in a recourse agreement, so Bobtail, we do recourse factoring, right? There are times when we do have to charge back carriers for loads that either, came in damaged or there's, some kind of claim from the broker and they're not going to pay the load. And in those, in some circumstances, we do have to issue a chargeback. But we do, as part of our service, help file claims on bonds and sometimes go after the shipper in certain circumstances where we think there's a good chance that we can get paid for that load. Other factoring companies might not do that. Other factoring companies are just going to charge back, and the only service that they're giving you is giving you that money up front. And if you don't make sure that your factoring company gets paid, sometimes they will just charge you back without much effort. So it is that is kind of a difference, but those could be two recourse agreements, right? They have the same name, but two very different services. Non-recourse factoring is a factoring agreement where the factoring company is taking on some more risk and saying, okay, if you haul a load for a broker and they go out of business and they file bankruptcy, then you don't have to get charged back for that load. That is usually how a non-recourse factoring agreement will work. So if they go out of business, then you won't get charged back for that load. I will say, though, that a non-recourse agreement does not necessarily protect you in every single circumstance where a broker wouldn't pay for a load. So there are lots of different circumstances. Maybe we can get into that, David, about there's lots of different reasons that a broker wouldn't pay for a load, and not all of those are necessarily going to be covered by a non-recourse agreement.
Thank you for the explanation.
Oh, I can't believe I just explained that in front of a lawyer. That was really
great job.
I feel like I just took an oral exam. All right. We have some more questions here. Jacob Nielsen, can you talk about double brokering? Jacob, I love this question because this was actually my last question that I skipped from my list. So thank you so much. I don't know how you got into my head. How to catch it, how to prevent it, what to do when it happens. David, can you tell us about this? This has been an exploding tendency in the industry. Can you talk about double brokering and with this rise of fraud in the industry and how it's affecting carriers and what they can do about it?
Well, there certainly has been an explosion of it as the freight markets have completely melted down over the last 18 months. So desperate people start to do desperate things. Fraudsters start to prey on people. And so we're starting to see a tremendous amount of it. Unfortunately, I will tell you that there's absolutely no sure way to protect yourself. There is no sure way to protect yourself. Some guidelines, certainly that I would use, and I'm certainly not meaning to offend anyone, and I'm certainly not meaning to try to exclude anyone. But one thing I think you really need to know as a motor carrier is it a brand new broker? In this transportation market, if there is a brand new broker, there shouldn't be many right now. because the transportation market's done nothing but contract for 18 months. So new brokerages shouldn't be popping up every day. And if you're hauling for a brand new broker, I would be leery. Do they have any references? Can you find any credit information on them? If you have a factoring company, are you having that factoring company really look at that broker? The other thing that I think that carriers have to do, and this is very difficult in these difficult times for you smaller carriers, but if the load is too high priced, if it's just too good to be true, it really is too good to be true. If you're seeing $4,000 freight, that's honestly, it's probably a double brokered load right now. If you're, I mean, of course, not heavy haul and maybe some refrigerated stuff's that expensive. But if you're seeing a dry van load for $3,500 or $4,000 right now, something's wrong, quite frankly. So be very leery about being seduced by high price freight. There isn't high price freight right now. And if there is, there better be a real clear and concise explanation for why it's so high priced. So stay away from high price freight, and quite frankly, be leery, or maybe the better term is just be a little extra careful with very new brokers, real new MC numbers, no credit or trade history. Right now, those are the types of entities that are committing double brokering.
Yeah, absolutely. And we actually have a whole article about this on our blog, and people can check it out. We deal with this all the time, right? As a factoring company, we see loads come in. One of the things that we also recommend is that you factor your invoice right away. Because if you send in your paperwork to your factoring company right away, at least, and I can only speak for Bobtail, but we can look at it as soon as it comes in, and we can try to identify, is this a double brokered load? We have a lot of resources in our toolbox and lots of people looking at invoices every day and analyzing them. And we can say, oh, okay, this might be a double brokered load. And in that case, we might be able to find out who the real broker is, or who the broker who's working with the shipper is, and get in touch with them right away. And so that means that we might actually be able to get paid for that load then, right? And meaning that we can then, pay you, or not avoid it, or that we can avoid a chargeback. So that's also something, if you're working with Bobtail and we have a mobile app. So even if you're the driver as well, if you're an owner operator, as soon as you get all of your paperwork, you can use our mobile app to just scan all your documents, send it in right away. And that gives us enough time maybe to see if something is wrong. The other thing is that if you're factoring with us, you can also call us. If you're about to book a load, or you've just booked a load and you think something might be weird or wrong, you can call us and ask us, hey, will you take a look at this? I'm going to send you the paperwork that I got, or the rate con that I got. Can you check this out and see if this makes sense to you? And then we can see if we think it might be double brokered or not. So that's some other advice that people can use. Excellent. And we've got Mia, you've got your hand raised and you've been so patient this whole time. Go ahead. What is your question?
My question is about claims. So how far back can the broker goes when it comes to payment? Because I remember you said they can go back, take 10 payments and stuff like that. So if they already pay, the 5 previous invoice to the factoring company, can they go back a month later and say, hey, I paid this, but I want the money back because I have a claim on this load that was done yesterday?
The answer is, under their agreement, they probably can. It's a terrible answer. It's a terrible process, and I don't like it, but they are probably within their claims period to identify and assert claims. And what they'll do is then, if they have 5 more invoices, they probably won't pay those. And that's why those offset provisions and some of those claims provisions in broker carrier contracts are just killers, because you might even think that you're past some of that, and they come back and do that. So I know it's not a great answer because I don't have necessarily a specific contract in front of me, but the answer is that they probably can. And I hate that, but I also want to be candid with you that, yeah, they probably can under their rights, under the broker carrier agreement.
I have been trying to research attorney companies who can help me with my daily issues. Most of the lawyers that I was trying to hire, let's say for 5,000 claim or something like that, they were saying it's not the worth to hire. It's not that money doesn't worth to hire a lawyer. You know what I mean?
I work with carriers every day, but I tend to work through their factoring companies.
Well, that's fine. Even with factoring company, if I'm using, if I do, I mean, my claims with Bobtail, you will represent Bobtail in that case.
Typically, that's how I do it. But I do want to say I evaluate every case on a case-by-case basis. I do represent carriers that don't have factors. The challenge for an attorney, and you've just hit on it, is I feel terrible for anybody that's out $9,000 on something, but I can't effectively handle that. And so that's why I like to, do I have a team or do I have collections people that I can refer you to? Do I have businesses that you could work with to try to collect that or collect some of that or buy some of that debt? So I try to use a variety of resources, but unfortunately to get a lawyer involved these days, if you don't have $40,000 or $50,000 worth of problem, it's very, very difficult to engage an attorney.
Okay, but let's say average amount is 40, 50.
That's a different story. Yep, that's a different story.
And when you say you said that the federal regulations, they say 9 months for the final claim. Ford factory gave me a low statute of limitations Carmack amendment uniform bill of lading, and they said with that law they have up to 2 years in order to file a final claim. Is that true?
No, that's not true.
That's not true. Gotcha.
Handling claims is a very specialized area of the law, and you should be comfortable in that attorney's experience in doing that. You don't want to hire a personal injury attorney to handle a claim.
Right.
Experience in that area is by far the most important thing to me. I saw a question flash up on the screen that I want to try to answer quickly. Someone said,
Sure.
how can we use the Carmack amendment or the Carmack law when handling freight claims? The challenge is that most of the big brokers will say you waived all your rights under Carmack. You don't have any of those. Your rights are only whatever our agreement says. So the Carmack law does get tough to assert. The Carmack law is in favor of the carrier. There's limitations on liability. There's time limits. How do you make claims? It's actually a pretty nice set of laws, but the big brokers in particular will say that you waived those. And you may have to have an attorney fight that and say, we didn't waive our Carmack rights, or at least try to assert that. But don't think the Carmack law is always available to you. A broker's probably going to say, no, we're not playing under that set of laws. You waive that, and we're playing under our contract only.
Understood. Abdul Rahim Mufti, you had another question. Your hand is raised, or maybe not.
Yeah, I got my hand raised. I don't even know how to put. Oh, there we go. Excuse me. So, if the load is double brokered, will the bond still pay for it?
Great question. It's a great question, and I have a terrible answer, and that is that I have been successful in getting bond companies to pay on double brokered loads when the actual carrier didn't get paid. But I have also had trouble with that, with other bond companies taking the position that, hey, we were a victim too, we're not paying. So there's some real mixed success there. But I recommend that if a load has been double brokered and you haven't been paid, that you at least try to file on the bond.
Thank you.
Great. Mia, did you have another question?
Yes, I wanted to know if we can clearly, if there's a claim and we know it's not our fault, let's just say the shipper did not load the truck properly, or they did not put pillow and things like that. If there is a claim, do we really have to accept the claim when we know for sure that, hey, this does not fall on us, the carrier, it falls on the shipper?
Wonderful question. And it's where the law goes this way and the practical goes this way. Under the law, if you've got load issues and problems issues, you should never accept that claim. You should fight that claim however you can and with whatever resources and people and assistance that you can. And you've got a terrific defense to that claim. But practically speaking, you're going to be put on your heels and you're going to be on the defensive because the broker is going to slam that claim down you and say, we're not paying you for that load and we're not paying you for the 10 before. And that's the way it's going to be. But no, you shouldn't accept that. If you know a shipper, I have one right now where the ice cream was loaded improperly. It wasn't my carrier's fault. There's absolutely no trouble with the load. The ice cream was loaded improperly at the shipper's warehouse. And we're not going to accept that.
Thank you.
Would it be safe to say, David, that people should be going, if they have a factoring company, that they have a better chance of fighting a claim through their factoring company than just on their own?
In my opinion, absolutely. And that is not a sales pitch.
Yeah.
But my experience time and time again is that the small carrier will be taken more seriously when a factoring company is sort of in their corner,
Sure.
and going to bat with them and for them on the claim. Absolutely.
Right.
I don't say this very often, but of all the reasons that you might have a factoring company, because brokers pay slow, because you need cash flow, for all the reasons,
Right.
in this day and age and in this market, one of the best reasons to have a factoring company is some claims protection.
Totally. Luis Ramos, I see you have your hand raised. Did you have a question? We'll take one more question and then we're gonna wrap it up here.
Hello, how you doing? How's everyone doing tonight?
Good.
Just had a question on, it happened to us being their broker. We're dealing with a broker for a few months. Credit was good. We did about maybe 7 loads. And all of a sudden, they just vanished, right? And they owned us about $19,000. Is there any way we could get that money going after the shipper? Because we couldn't find him. Obviously, he had a plan. I guess he ended up owning over $200,000 to different carriers in total. Is there any other options that we have? Because again, we did move some loads. He did pay the first 2 loads, but after that, he just went MIA and no one could find him.
Certainly try to get bulldog collectors on that to try to collect some. They'll probably go after the shipper immediately. You should at least be attempting to get payment from the shipper. Absolutely. That's a classic scenario where I recommend some attempts at shipper collections.
Are they legally, do they have to pay us?
Yeah, it's a super question. And I want to reiterate something that I said earlier.
Okay.
There is no black letter law. There is no statute. There is no regulation that says that they have to pay. There is common law. There is case law out there in certain jurisdictions that say the carrier must be paid even if the shipper's got to pay twice. And so based on some of that case law, based on some of that common law, a good collector, a good attorney citing that law should at least try to collect from the shipper. Absolutely.
Okay. And I appreciate it. Thank you. Thank you for the advice.
Yep.
I appreciate that.
Thanks, Luis. All right. Thank you so much, David. And I think what you had said before about factoring, that leads us very nicely into talking about Bobtail. Just before we wrap it up, we do want to let everybody know that we do have a factoring service. You can learn more at bobtail.com. And we do work very hard, and I would say harder than a lot of other factoring companies, to get people paid for in interesting situations, let's just say. I
want to thank you for the opportunity. It was a real pleasure.
Thank you so much.
And hopefully I'll try to find a couple of resources that you can link to and post for your audience as well.
Excellent. Thank you so much.
Right.
And I want to bring Veronica Blanco up on our stage to talk a little bit more about factoring and what it means to be really protected and accompanied by a factoring company.
Sure. Thank you so much, Caroline. Thank you, David, for all the valuable information we learned today. Now, one of the great things that differentiates us from many factoring companies is we don't work with long-term contracts. There's a huge difference out there. A lot of carriers don't know this, but factoring companies that have a very long-term contract, such as a year, 2 years, normally these come with a termination fee, very high termination fees that I've seen up to $15,000. And these are strategies that are being used so that you can stay with that factoring company. They'll promise you a low rate in the beginning, just kind of to, lure you in, but there are other fees involved. Bobtail does not charge you any other fees other than whatever we're going to charge just to upfront that money directly. We don't work with invoice fees, reserve fees. You're not going to see any of those type of fees. We're a very transparent company. And the reason why we are transparent is because our history comes from, the owner of the company used to be a carrier. His father used to be a carrier. They needed factoring companies back in the days. They realized there are no factoring companies out there that would just upfront you the money, no long-term contracts. We needed these type of companies. He created his factoring company. There's a 30-day agreement with us. We don't force you into a long-term agreement. So we know what you're going through. And that's the whole idea. We're here to work with you. Another thing that is very important to mention is if you are already in a long-term contract with a current factoring company, don't hesitate to call us. We can assist you in trying to understand your contract and seeing what options are there to have you, pretty much be transferred to us, or at least do some form of buyout process that can help you get out of that contract.
Wait. Luis Ramos, you've got a question, or you've got your hand up.
Yeah, quick question.
Yeah.
Is there anything you could do, any pointers you give us to know if a company is double brokering, or any signs, any red flags, like, hold up, maybe now work with this company because we're seeing XYZ, right? Or these are the signs that are coming up. Is there anything we could do, right? Because everyone knows they go off a low board, go out there, you might see a 97 score, 20 days to pay, but then there's actually something really going on that we can't see, right? And maybe you have the technology or just the input information, be like, hold up, I think this company right now might be on the verge of doing something that might not pay you in the future. Is there anything we could do, any insights you give us?
Yes, I have a whole article for you, Luis. I'm going to share it in the chat here. So go and to anyone else who wants these tips, everything that I'm going to say is going to be on this article as well, and in the video that's on that page as well. But okay, so I've got, I'll summarize them here though. One is something that David touched on earlier: be cautious of rates. He said, be cautious of rates that are really high. If you see something that is way far and beyond the average of what that load or what that route is, what that lane is paying, let's say 40, 50% above what the market rate is, be very, very careful with that. Why? Because that is something that double brokered loads will use to lure you in, to confirm that load, haul that load, and then they'll disappear, right? Now, the reverse of that is a very, very low rate. And the reason that a really, really low rate is also a red flag is because some double brokers will pay for the load. It's double brokered and they're making some money off of being that second middleman, right? But they will end up paying the carrier for the load. They're just going to pay a really, really low rate because they are making money on what the broker gave them the load for, right? And so if you see a rate that's well below the average, and you can see this on the DAT load board, if you don't have a load board, if you're not using a load board that's going to give you that information, I recommend that you pay a little bit extra to your load board so that you can get that information of what that 7-day or 30-day average, I think they give you on there. So if you see something that's way higher than that or way lower than that, be very, very, very cautious. And hopefully if you're going with one that's way lower than that, hopefully you just don't even take that load, right? Another way is to verify broker's legitimacy. This you can do. FMCSA has a website. There's also another website called Freight Validate. So if you look up that is a free tool that one of our speakers in a previous event showed us, where you can see he has a whole network of brokers, and that service validates brokers and carriers identities and makes sure that they're not fraudulent brokers. Another way to validate the contact information of the broker. So if you see a load that's listed on a load board and the contact information doesn't match the information on the broker's website, that can also be a red flag. So if you see, let's say on the load board, you see a Gmail account, and on the broker's website, they have a different domain, or you see a phone number even that's different on the load board than what they show on the website, just go ahead and contact the contact information that's on their website and say, hey, I saw this load. I had a question. I wanted to make sure this was right, but it had different contact information. I just wanted to check and make sure. Because that could be also a red flag that the contact information doesn't match. I would also say that when you're looking at an email address, make sure you look at those email addresses pretty carefully. Sometimes people will put an extra word or an extra letter so that it almost matches the email address of the real broker. But it's really hard. I have heard that sometimes this can happen where they hack into the actual broker's domain and are using the actual broker's domain, but that's pretty rare. Normally what they'll do is they'll like add a .llc or just something else into that broker's domain. So just look really, really careful at those. So freightvalidate.com was another one. Pay attention to communication. So if they give you the load, if you confirm the load and they don't want to hear from you again, and they're like, stop bothering me, or they're completely unresponsive, that can be a big red flag, because the broker should be in touch with you about that load, making sure that it's getting in on time, making sure that you're doing the right things. And then again, on the flip side, we're talking extremes here, right? If you're noticing an extreme in any one of these situations, it can be a red flag. So once you deliver the load, if they are screaming at you for you to get them the bill of lading as soon as humanly possible, that is also a red flag. If they're asking you to send it to them by text, if they're asking you to send it to them via WhatsApp, and they're not following a process that should be laid out either by email, but hopefully the broker has their own system for you to upload documents into, be just very, very cautious of that. And in fact, if you're factoring, you shouldn't necessarily even have to send them directly the documentation for the load. Let your factoring company do that. Again, there's a difference between what's reality and the shoulds and what actually happens out on the ground in the real world. But if you can, just agree with all of your brokers, hey, my factoring company is going to send you all of that so that it all gets to the right place and gets to the right people at the right time, even better, because then you don't have to give your very, very valuable documents to anyone that shouldn't get them, right? And double check the documents. When you get a rate con, make sure it doesn't look weird. I know that sounds really kind of generic, but for example, we see all the time on rates of on rate cons, the ones that are fraudulent will often have weird font in them. So there'll be mixed fonts in the names, or something will look like if it's clearly been edited. Thankfully, some of these fraudsters aren't very detail oriented, and so they end up making really stupid mistakes on the rate con. But if you're just doing this day to day, and you're just getting documents back and forth and uploading and emailing, sometimes you don't look really, really carefully at those things. So just take a pause, take a second, look at it. It'll take you 1 minute to make sure everything looks good. Sign and date BOLs. So if you are not doing that, do that. One, we need you to do that anyway to factor a load. But if you're not doing that and you send a BOL that wasn't signed and dated and had your carrier's information on it, then when the broker or the shipper gets that bill, when the broker gets that bill and they just pay it because they didn't see that a different carrier actually delivered the load, there's nothing for them to question, right? If you have drivers, make sure there is training on this when you hire a new driver. Fraud prevention, this is a critical part of driver training, because they are the ones that are going to be handling a lot of those documents and seeing what's happening on the ground. I hate to say it, if there are any dispatchers on the line, There are plenty of great dispatchers out there and great dispatching services. Some carriers swear by them, and that's awesome. But if you have not been blessed to be touched by such a broker or such a dispatcher in your life yet, I suggest that you dispatch your own loads. Because when you're first starting out, you need to build relationships with customers and you need to understand how this industry works. And I think too often carriers just outsource that without really thinking about it twice. And again, like I said, there are some dispatchers that are going to do a great job, but there are a lot of dispatchers that are going to do a terrible job and are going to not only lose you business, but might even be fraudulent, and they might be causing fraud on your accounts. So be very, very careful. And if you are using a dispatcher, please don't share your login credentials to your factoring company or your factoring account with them. You should be in charge of your factoring account. So please be very careful, very, very careful, and don't share your credentials really with anyone, except the person who, if you are managing your own collections and invoices, you should be the only person that's accessing that account. I think I already mentioned factor your invoices quickly. That's a big one. So if you didn't hear me say that before, as soon as you get that paperwork, send it to your factoring company as soon as possible. I can't speak for other factoring companies, but at Bobtail, we verify and look at those documents very carefully, and we can often recognize if it's a brokered load or not. Unfortunately, we don't always get those invoices right away. If you don't send us the invoice, if you deliver a load on Monday and you don't send the invoice until Friday, chances are that the person who double brokered that load has already been paid via quick pay from the real broker. And in that case, the broker is never going to pay twice for a shipment, right? So factor your invoices as soon as you get them. We make it really easy at Bobtail with our mobile app, with our desktop app. It should be very seamless for you to send in those invoices right away. And of course, the last one is to trust your instincts and your own common sense. If a customer is giving you reason to doubt them, do some extra research. Just go to their website, verify contact information, do all of these things that I've already mentioned. I mentioned a lot of things, but they really don't take all that much more time on every load. Maybe it's 5-10 minutes tops that all of these little steps are going to take you. Make yourself a little checklist that you can check off. We do this all the time in marketing. I can't tell you the numbers of times when we're like, oh, we messed up on that email. Okay, we need to add that to the checklist. So just make yourself a little checklist to go through, verify brokers. All right, I'm going to go to freightvalidate.com. I'm going to do this. I'm going to do that. It's not going to take you more than 10 minutes. And if you're factoring with us, call us. If you have a reason to doubt, call us, especially if you haven't delivered the load yet, because then you could cancel if you think it might be double brokered. We can look at the rate con for you and see if it matches what we have in our system for that broker. If you haven't delivered a load for them yet, we have probably worked with a carrier that's already delivered a load for them. We know what the rate con looks like.
Yes. I appreciate it.
That was a very long-winded answer to that question. And I'm thinking we should probably do another series of events on avoiding fraud and double brokering, because I know this is a huge topic right now. Fraud has just exploded in the trucking industry. I know Jose has been on that call before. So maybe we'll do another one of those next month. All right. With that, thank you so much for joining us for our event tonight. Again, we have recorded the session, so if you joined late, you haven't missed anything. We will send you the recording to your email. That will come either Monday or Tuesday of next week. And I really appreciate everyone coming and answering and asking the best questions tonight. Thank you so much. Have a great night.